Welcome to Chapter 4, Common Law, Statutory Law, and Administrative Law. The law is complex, there's no doubt about that, but it can become less baffling if we understand the different types of law and how each type is made. Progress everywhere today does seem to come so very heavily disguised as chaos. Common law is simply judge-made law. 200 years ago, almost all law was common law. Most new law today is statutory. Common law predominates in tort, contract, and agency law, and it's important in property and employment law as well. It's based on stare decisis, meaning let the decision stand. It incorporates predictability as well as flexibility. Historically, the common law has required no action at all from those who witness a person in distress. The bystander has been free to walk away, laughing if he wished. Over time, changes in society's norms have an effect on long-standing common law. An example of this is a law that applies to bystanders in emergencies. Under common law, bystanders have no obligation to assist a victim in an emergency. Over time, courts have created exceptions, making employers obliged to help an employee who is suddenly stricken with an emergency situation when the employer is present. Some courts now hold that anyone witnessing an extreme situation, or if there is a special relationship, such as patient-therapist, should be required to help, though this is not universal. Is the bystander rule immoral? What are the differences between law and morality? Law clearly differs from morality. Anytime the two strongly diverge, it's worth close scrutiny. What about Good Samaritan laws? Many people misunderstand the effect of Good Samaritan laws, believing them to obligate bystanders to render assistance to someone in need, but this isn't the case. It merely protects people who decide to help someone from getting sued if they do more harm than good. If you've received certifications for completing Red Cross First Aid, Junior Life Saving, or CPR courses, you may have actually been told that such certification imposes a duty on you to provide assistance to bystanders when legally you aren't obligated to do so. You may recall from years ago the final episode of Seinfeld in which Jerry, Elaine, Kramer, and George laughingly watch someone being mugged and robbed while they do nothing to help the victim. They're arrested and charged with violating a fictional Massachusetts town Good Samaritan law for the failure to come to the victim's assistance. The show ends with the four characters sitting in jail. Though Massachusetts doesn't have a Good Samaritan law like it was depicted in the show, it nonetheless created a good topic for conversation. Most new law is statutory and passed by either a state legislature or the Congress of the United States. People who vote have some control over statutory law. We elect the state congressional representatives and the United States senators and representatives. Suppose you were on the state Supreme Court and faced with a restaurant choking case. Should you require restaurant employees to know and employ the Heimlich maneuver to assist the choking victim? If they do a bad job, they could cause additional injury. Should you permit them to do nothing at all? Is there a compromise? What social policies are most important? It appears that no state requires restaurant employees to give first aid to choking victims because of the possibility that they could do more harm than good. But some states do require the restaurant to respond. The Wyoming court has ruled that a restaurant has a legal duty to summon aid for a choking victim, but no duty to provide the aid itself or train the staff to do so. Any member of Congress can initiate a bill. It's then debated in a committee in the House where it's introduced. From the committee, it goes to the full House for a vote. If it passes both houses this way, it goes to the President for his signature. If the President signs it, the bill turns into a law. New bills are proposed all the time because new issues or concerns develop all the time. When people find a judicial ruling unfair or no longer effective, then Congress may try to pass a new statute to undo the decision of the court, unless, of course, the decision is based on the U.S. Constitution. It's also incredibly important for criminal law to be very clear so that it's not left up to judicial interpretation whenever someone's on trial. Let's say that you just signed a 2-year lease with a landlord for an apartment. The rent will be $1,000 a month. A clause in the lease requires payment on the first day of every month. The clause states that the landlord has the right to evict you if you are 1 day late with the payment. You forget to pay on time and deliver the check to your landlord on the 3rd day of the month. He starts an eviction case against you. Who should win? If we enforce the contract, what social result does that have? If we ignore the clause, what effect does that have on contract law? Virtually every state would refuse to enforce the clause, finding it unconscionable. An unconscionable clause is one that grossly and unfairly favors the party with more power. The example I just gave is such a clause. But the problem with permitting this flexibility to enter into the contract law is that we now are less certain of being able to enforce contracts generally. A party who wishes to get out of a contract may attempt a claim of unconscionability. Sometimes wording is ambiguous, which leads to statutory interpretation. New laws must be interpreted by the courts. Plain rule meaning means that the courts must use the common sense definition of words. Legislative history and intent means that sometimes the court can look to the reasons behind the law to determine the legislature's intent. Public policy means that the courts will use accepted social policies such as reducing crime or providing education to interpret a law. Once a statute has been applied by the courts, its interpretation becomes a precedent to be used in future court cases. In today's political climate, running a campaign for political office is an expensive endeavor. Financial contributions to candidates or political parties come from many sources. Some limits have been placed on contributions, such as those enacted in 2002, but loopholes still exist. For example, in the 2004 presidential election, tax-exempt committees raised millions of dollars to try to influence the election. Donors usually expect to receive some benefit, such as favored treatment in future legislative issues. Supporters of contribution limits aim to equalize the access to politics for the rich and poor. Opponents claim that the First Amendment guarantees their right to support whomever they choose. The very green bottom line is this: money talks, and often it talks loudly in the political arena. Federal agencies such as the Federal Aviation Agency and the Federal Trade Commission and the Bureau of Land Management have the power to make regulations. Agencies were and are created to fulfill a need. Someone needs to oversee changing technologies and practices and their effects on society. An agency is created when Congress passes enabling legislation, which describes a problem and defines the agency's powers. Agencies often have considerable power in their areas of specialty, sometimes leading to controversy. The Administrative Procedure Act regulates agencies in an attempt to reduce controversy. Hiller Systems Incorporated was performing a safety inspection on board the Cape Diamond, an ocean-going vessel, when an accident occurred involving the fire extinguishing equipment. 2 men were killed. The Occupational Safety and Health Administration, OSHA, a federal agency, attempted to investigate, but Hiller refused to permit any of its employees to speak to OSHA investigators. What could OSHA do to pursue the investigation, and what limits were there on OSHA? OSHA could and did issue a subpoena requiring Hiller employees who knew of the incident to testify at an OSHA investigatory hearing. The principal limits on the subpoena are that it be within the authority of the agency and reasonably relevant to some investigation. In this case, the court held that OSHA's subpoena was a valid exercise of its power within its area of expertise, worker safety. Executive federal agencies are part of the executive branch and under the control of the President. They usually support the President's policies. For example, the FBI, Independent federal agencies are not part of the executive branch. The President does not have the power to fire the head of these agencies. Some examples of these agencies are the Environmental Protection Agency, the Securities and Exchange Commission, the Federal Communications Commission, National Labor Relations Board, and the Federal Trade Commission. It's ironic that the effects on our lives of administrative regulations is so pervasive, yet the process by which administrative agencies create their regulations is rarely before us. Can you remember the last time you saw a movie or TV drama where the protagonist delivered an impassioned speech to a regulatory board? It rarely happens. But you could make a good argument that we experience the work of administrative agencies more often than other lawmaking bodies. The Administrative Procedure Act was passed in 1946 to bring uniformity and control to many federal agencies. It regulates how federal agencies make rules, conduct investigations, hold meetings and hearings, and reach decisions and obtain and release information. There are two types of rules: legislative and interpretive. Legislative rules require that businesses and people act a certain way and have the effect of congressional statutes. Interpretive rules do not change the law. They define or apply the laws to new situations. There are three types of rulemaking. With informal rulemaking, the proposed rule must be published and the public should be allowed to comment on it. With formal rulemaking, they must hold a public hearing before establishing the rule. Hybrid rulemaking uses elements of both of the above and perhaps the proposal and comment with cross-examination but not a full hearing. When an agency wants to investigate a business, sometimes the business freely complies and gives up whatever information they have. In some cases, however, subpoenas are given to a business in order to make them appear at a hearing and produce evidence, sometimes documents. The U.S. Product Safety Commission investigates hundreds of consumer products every year and urges a recall of products they consider dangerous. Agencies, of course, also have the power to subpoena, and they have the power to do a legal search of a business in order to take evidence of wrongdoing. This usually requires a warrant before they search. Some industries are closely regulated and may be searched at any time without warning. Agencies also have the power to adjudicate or hold a meeting to decide how to proceed with an issue. They hold a hearing before an administrative law judge. The parties have counsel, but there's no jury. It's informal, so both sides present evidence, and then a judge makes a ruling based on the testimony and the evidence. If either party is unhappy with the decision, the loser may appeal to an appellate board who may make a de novo decision and ignore the administrative law judge's decision, in which case the appeal would go to a federal court. The enabling legislation that created the agency places controls on it through requirements and restrictions. This is statutory control. The President has control over agencies through political pressure and through nominations of agency heads. This is a form of political control. Congress controls the budgets of agencies. They can eliminate funding for any program or an entire agency. Congress can also amend enabling legislation to place limits. In order to keep the system balanced, there are limits on agency power. A party injured by an agency decision is entitled to an appeal in a federal court after all appeal options are exhausted within the agency itself. The court must consider the facts as stated by the experts in the agency and the law as interpreted by the agency. Citizens are also protected by the Freedom of Information Act, which allows any citizen to request information from an agency. The Privacy Act prohibits agencies from giving information about a person to other agencies without their consent, although there are some exceptions to this rule. As I stated in the beginning of this chapter, the law is complex. The subject becomes less baffling, however, if we understand how society creates law. Congratulations, you made it through the end of Chapter 4.